He owes $26,000 in rent, you're saying? How do I say this nicely? You got a big mountain of evidence to pull together if you're going to convince any of us that this is the case, okay?
Well,
you can't
no,
just come in here and say, he told me he wanted to give me the property.
No, I understand that. I do understand that.
Well, then you're living in a
this
property
thing
that
turned
you
out.
don't own, right? Are you living in a property that you don't own?
Yes.
Okay.
This defendant walked into court acting like he was the rightful homeowner, even though he's literally being sued for over 26 grand in back rent. And the wild part is he fully believes he owns the place because the landlord supposedly told him on his deathbed. I'm not kidding, that's his entire defense. He has no deed, no paperwork, literally nothing. And the judge literally humbles him instantly with one simple question that completely blows up his whole story. Let me know in the comments if you think he genuinely believed he owned the house, or if he was just trying to dodge paying rent. Let's dive in.
Tippett Family Trust versus Paul Schmitz.
Good morning, Your Honor. Peter Staver appearing on behalf of the plaintiff.
He owes $26,000 in rent, you're saying?
Yes, Your Honor. There hasn't been, Your Honor, this is basically a Tippett Family
But you
Trust.
served for termination of tenancy.
I did, Your Honor.
Okay. Your
Termination
name?
of tenancy is actually what we're seeking.
Paul Schmitz.
You have the right to a lawyer. You have the right to proper venue. You have the right to a jury trial. If you want to speak to a lawyer, you can do so. There's no application for funding involved here since they're just doing this for termination of tenancy. They're not even asking for a possession judgment, but they do have a supplemental complaint for money damages. So they're asking that I order you out of the property, and they're asking that I enter a judgment against you for $26,400.
Well,
And
that's can't be correct. Jerry was not only my landlord, he was a close friend of mine. And,
hang on a second.
and
Hang on a second.
okay,
Do you understand all the rights that I just enunciated?
did I have a right to an attorney?
Yeah, you want to speak to a lawyer?
That would be great. I've been talking to the trust, to Daryl.
Who's Daryl? Everybody's throwing around these.
Daryl's the guy from the trust that I've dealt with over the last, well, I've known Daryl for 20 years.
I don't know who Daryl is.
Your Honor, Daryl Lawson is the successor trustee of the Tippett Family Trust.
Okay.
But I've been dealing with him and Jerry, was Jerry Tippett's niece's husband.
Well, you guys.
And this has been, Jerry told me that the house was mine.
Is Jerry dead?
Jerry died. I administered his last rites in the hospital.
What do you mean? Are you a priest?
No, but I anointed him with oil. But I'm saying.
Okay, I've covered some strange landlord-tenant cases on this channel, but the second he said he anointed the landlord with oil, I just knew we were dealing with a different level of confusion. I mean, you could tell he cared about the guy, but caring and owning a house are two very different legal realities. Real estate law doesn't take emotion or deathbed conversations. It simply takes paperwork, signatures, and a deed. The judge keeps waiting for something in writing, but when the defendant admits there isn't a single document, you could just see the case fall apart instantly. I know in real life, promises mean pretty much everything to people, but in real estate, promises just don't hold up.
There was no reason. They had an issue with wills and whatnot.
Listen.
Yes. Jerry wouldn't have told me that the house was mine if he wasn't that type of a person. And
Hang on a second.
they
Hang on a second.
came
Hang
up-
on a second.
Yes.
Did
Yes.
he give you a quit claim deed at the time that he told you this?
No,
Did he give you a copy
he was
of
in hospice.
Hang on.
Well, he had told me
Hang on.
prior to.
Hang on. Did he give you a copy of his will that said it was yours?
No, he
Hang
had
on.
talked to another attorney. That
Hang
was
on.
the problem. That's why it's taken 2 years
Sir.
to get to court.
Sir,
Yes. Yes.
you don't really think you're going to gain ownership of the property by telling me that a man on his deathbed told you that you
No, it
own
was
the...
prior to his deathbed.
You don't
Yes.
really... Sir, let me
Yes.
finish my question.
Yes.
You don't really think that you're going to gain ownership of the property by coming into court and telling a judge, listen, you're going to interrupt me again, and I don't want to be interrupted again. You've interrupted me at least 2 or 3 times. Just let me finish the question. Do you really think that you can walk into a courtroom and tell a judge, listen, my buddy here told me I was going to own the property. I own the property. I don't care if it was on his deathbed, a week before, a month before, or 14 years before. That kind of thing needs to be in writing. And I don't know where you got any kind of evidence that this gentleman was transferring the property over to you, but you're really, how do I say this nicely? You got a big mountain of evidence to pull together if you're going to convince any of us that this is the case, okay? You can't just come in here and say, he told me he wanted to give me the property.
No, I understand that. I do understand that.
Well,
We
then
didn't
you're
know
living
how
in a
this
property
would turn
that you
out.
don't own, right? Are you living in a property that you don't own?
Yes,
Okay. Did you ever pay rent on the property?
yes,
How much?
for 15 years.
How much a month?
Depending, it was anywhere between 800 and 1,100 a month.
You guys didn't have a set amount of an agreement, or in the last 2 years, let's say what it was?
It's a front and back. My mother-in-law lived in the front. We took care of her till she
I
passed.
don't need to know that.
I understand that.
I'm just asking you how much, when did Jerry die, by the way, whoever Jerry is? When did
It's been about 2 years.
is that right, Mr. Staber?
I don't have the exact date. Yes, Judge, that's approximately right.
Were you paying rent up until he died?
Yeah, I paid it afterwards.
You did?
Yes.
Why would you have paid it afterwards if you just got done telling me that he told you owned the property?
Then comes the moment that ends everything. The judge simply asks, if you think you own the house, why did you keep paying rent? That one question completely destroys his argument. I mean, there's honestly no coming back from that. If you truly believe you're the homeowner, you don't keep handing rent checks to the estate. The second he admits he kept paying, I mean, the judge knows he never believed the property was his in the first place. You can almost see the realization hit him as he says it.
Because nobody could tell me who owned the house, and Jerry had told me that he was leaving.
Are you $26,400 in arrears?
No.
How many dollars are you?
I haven't paid
Hang on.
anything in about the last year.
Oh.
I had a stroke a year ago.
Okay, and how much was the rental amount?
Pardon? I'm sorry, I'm
How much?
cognitively.
Okay,
I had a-
I'm sorry. I'm sorry.
70% blind and
I'm sorry. I really am.
I'm.
Just tell me
cognitively
something. The last time you paid rent, what was the rental amount? Monthly amount?
1,100.
All right, so you agree that you owe $1,100 at least times 12, right?
Yes,
So you owe 13.2.
yes.
Mr. Staver, you think he
How?
owes 26.4, that he didn't pay it since Jerry died? Am I right or wrong?
You're right, Your Honor, but I could work this out at 13-2.
In a money judgment?
Yes.
Do you want to go into a breakout room with this gentleman and talk to him and see if you can work everything out?
Certainly willing to try, Judge.
Okay, so we're going to take you to a computer. This is their lawyer.
Okay, I'm gonna have a tough time. I had my phone, it's got my seeing AI.
Hang on a second.
Yes,
You're going to have a tough time with what?
I'm blind. I have seeing AI on my phone that
I
reads
see.
for me.
Well, he'll walk with you over to a computer,
Oh, that's
okay?
fine.
And we'll set you up with Mr. Staber, and you two see if you can resolve it. And either way, you're coming back in front of me, okay?
All right.
Thank you, Your Honor.
Thank you very much. I'm going to do this one real quick. Tippett versus Schmitz, 2502513. And Mr. Staber, your name?
Good morning, Your Honor. Peter Staver appearing on behalf of the plaintiff, the Tippett
Mr.
Family
Schmitz,
Trust.
your name?
Paul Smith.
Did you two talk, and is there a resolution?
Yes, we did, Your Honor. We do have a proposed resolution.
Okay, go ahead.
Your Honor, what we've agreed to is that Mr. Schmidt will vacate the premises on or before September 1. For the month of July and the month of August, he will pay $1,100 a month for each month's rent. As to money issues, Your Honor, we have some difficulty. He believes he has receipts, et cetera. We've agreed to an adjournment for 2 weeks for him to produce any receipts he might have that shows rental payments he may have made. So we don't have an objection if we can agree that additional 2 weeks for him to produce any kind of payments. He's also given me a phone number where I can reach out to him, so I will talk with Mr. Schmidt. We'll see if we can't resolve the issue of that. But that, we hope that will give him adequate time to completely vacate the premises, best for both parties.
So you're gonna prepare an order, a judgment that's going to say the defendant to vacate on or before September 1. There will be a September 1 writ date.
Yep.
He's going to pay $1,100 for August and September. And is that true so far?
No, Your Honor, it'd be $1,100 for July and August, vacate by September.
I'm sorry, for July and August, my apology. And
then, Your Honor, if we could have 2 additional week adjournment.
and then the issue of money damages. So you just prepare a possession judgment that just says on there, writ date of September 1, and on the further orders, defendant agrees to pay $1,100 for the months of July and August.
Okay.
And I'd like that to get today, please. Is that what you agreed to, sir?
What, the $1,100 today? Oh, to come back and,
Wait a minute. You agree to vacate by September 1.
yes,
You agree that you're going to pay $1,100 in rent for July and August.
yes,
You understand they're asking for a substantial amount of money damages.
yes.
Hang on.
We're
Just deal with me. I know you're going to try to work it out. That's fantastic. But right now, you understand they're asking for a substantial amount of money damages,
Yes.
right?
Yes,
And you understand and agree that you have to be out by the 1st of September.
yes,
And you understand and agree that you're going to pay $1,100 for the months of July and August.
yes,
And then on the further orders, you're going to not only put that, counsel, defendant agrees to pay $1,100 for July and August, semicolon, trial of money damages to be set by the court. And then we're going to set a final pretrial on this at 10 a.m. Do you understand that, Mr. Schmitz?
yes, can I get,
What really surprised me is how the ending played out. The landlord could have pushed for every penny of that $26,000 balance and probably won, but instead they decided to be practical here. Just let him stay 2 more months at regular rent and then get the house back peacefully. I mean, I feel like that's incredibly generous considering how chaotic his defense was. It shows the plaintiff's attorney understood this man isn't dangerous. He's just confused and probably struggling financially and medically probably too. Instead of crushing this dude with a massive judgment he'd probably never be able to pay, they probably just want him out without a fight, so I really do understand that. In an eviction court, this is about as close to mercy as it gets.
Yeah, but we're going to give you notice. Does Mr. Staver have your permission to sign your name to a possession judgment that calls for you to vacate by September 1 and further states the trial the issue of money damages will be set for trial in the future, and you're agreeing to pay $1,100 for July and August of 25. Since you're unrepresented by a lawyer, you have 3 business days to come in here and fill out a motion to set aside the judgment. You have 10 days to appeal. Do you understand that?
yes, sir.
All right, Mr. Staver, have I covered everything adequately?
Yes, you have, Your Honor. Thank you.
All right, so that's what we'll do. And then hopefully you guys can talk and figure out a way to resolve this before you even come back. But if not, we'll just set it for trial in 2 weeks, okay?
Thank
Thank
sir.
you, Your Honor.
Best of luck,
Appreciate the
guys.
time.
Thank you very much.
On one hand, you feel bad for the guy because he clearly loved the landlord and thought they had some kind of spiritual agreement. And on the other hand, the law can't run on sentiment. It runs on documents, deeds, and proof. I mean, you guys would be shocked how many people walk into court saying something was promised them, like a house, and almost none of those stories survive once a judge asks basic questions. But yeah, I really do respect how the judge handled this one. As always, he's just calm, patient, and pretty firm enough to keep the case grounded in the actual law instead of wishful thinking. So in the end, the settlement was probably the best outcome for everyone. No crushing debt, no immediate eviction, and the trust gets their property back without a fight. Let me know in the comments if you think the landlord let him off way too easy, or if you think this was the fairest way to handle it. Thank you so much for watching, guys. Make sure to like and subscribe as always, and take care.